Welcome back. You're still watching Kenya's Choice here on 23rd of August 2022. And you're looking at the 9 petitions that have been filed at the Supreme Court. They have to be heard and determined within 14 days. Of course, there are some preliminary processes that have to be undertaken, including surveys of the respondents for them to have an opportunity to respond, and of course for the petitioner to file something else after that response. I'm just looking at the basis of these many petitions, and you'll find that including David Kariuki Ngari is saying the basis is that the 4 commissioners who disowned results, the verification and tallying by IEBC is a responsibility of the entire commission, not the chairpersons, and the quorum of the commission when they're meeting is half of the IEBC commissioners, not anything less than that. And of course, they're also talking about that some 8.21% of votes were not tallied and verified before the final declaration was made. Then John Njoroge Kamau, in his petition, says that Chebukati again acted alone. Postponement of elections in Mombasa, Kakamega, and 4 constituency elections suppressed voter turnout and, of course, affected what would be termed as a fair process. That's according to the petition. Ballot paper, that there was non-involvement of commissioners in the printing and receiving of those ballot papers, which he says is against the law. Then also Juliana Nyokabi, Joseph Mutua, Simon Jenga, in their petitions, they're saying that again, Chebukati acted alone in the final processing of the presidential election results, that not all results from the constituencies were announced at the National Tallying Center at the Bomas of Kenya. The IBC did not confirm threshold of 50% plus 1 before declaring William Ruto president-elect, and that special groups were not considered in voting procedures. For instance, hospital workers, security workers, poll workers, defense workers who are on duty during the election, and of course all the persons in the society. Helaf Khalifa raises several issues, including that Chebukati acted alone, that not all from 34Bs were read out at the National Tallying Center, that IBC did not confirm the threshold of 50% plus 1, that IBC technology was compromised and vulnerable to infiltration, and there was no backup to electronic voter identification, obviously, on the election date, and also touches on the KPMG report that it was never made public. That is the audit report. It had some issues that were highlighting on the credibility of the voters register, never made public, never implemented, and that also there was supposed to be a meeting between the auditor, KPMG, with the Smartmatic company, the one that was responsible for the supply of technology. Issues were raised, but there was never a meeting facilitated by IEBC. So they're saying that this now touches on the credibility of the process. Goes ahead to say that there were some 487,000 duplicate records in the register that were never fully dealt with, and therefore this would pose a threat to how credible the register is. For the Okiya Mtata petition, talks about the voter turnout, that at some point, one of Wafula Chebukati on August 10th declared to the country that 65.4% of voters had turned out to vote, but when it came to the final declaration, the turnout was reduced to 64.77%. He says that because of that, there appears that there are some 140,000 votes that were never included in the final tally. And based on that, therefore, if the final tally of William Ruto is as what was put by Wafula Chebukati, then it turns out to be 49.99% for Ruto, 48.37% for Raila Odinga, and therefore doesn't meet the threshold of 50% plus 1. Of course, we know there was a bit of confusion on August 10th in terms of the voter turnout. That day, Wafula Chebukati corrected himself and said that it was actually 64.6%, but obviously that was in error based on our calculations. But again, it's a question that is before court. Raila Odinga, among other issues, says that there were inconsistencies in the official reports on voter turnout, that 50% plus 1 threshold was not correct, that there was manipulation of voter turnout in the KIMS kits versus what was declared in the Form 34C, that there were some foreign nationals, the 3 Venezuelans, who had super administrative rights in accessing the system of voters, and then 19 other foreign nationals and administrator rights had administrator rights to IEBC systems, and that they could remotely access and manipulate entire IEBC data. says that there was evidence of staging that a temporary storage of Form 34 is in an external address to allow an interceptor to manipulate the forms before re-uploading them. This is what they're saying. They're also saying that they have evidence that there was hacking that was done and will be proved before a court. And of course, these are some of the bases of these petitions. And joining us now is Charles Kanjama, who is an advocate of the High Court. I'll give you a few minutes to cool off. But Bashir, when you look at those grounds, how important are they going to be? Because you see, again, the basis being about the 4 commissioners, then them saying the voter turnout was not very clear. There was a bit of confusion. And that because of that, the 50% plus 1 vote was not achieved as a threshold.
You see, Sam, when you look at the Constitution, you look at Article 138 of the Constitution. Before, and you also, when you look at also Article 81 of the Constitution, the kind of process that takes place is supposed to be simple, accurate, and verifiable. In other words, has the process been as such? When you move away from there and you go to now Article 138, we have to ask ourselves, in as much as we argue that the Constitution bestows upon the returning officer of the presidential election or the presidential election results on the chairperson as the chief returning officer, what is the place of the other commissioners? Because when you look at Article 138 sub Article 3, it still gives the commission as a whole the power to tally and verify the results. So the reason as to I think some of the petitioners are documenting this as part of their grounds is to try and see, we have the chairperson here who has declared these results as the outcome of the electoral process, and on the other part we have under Article 138(3) the commission that is supposed to tally and verify the results, 4 of them. In other words, 4 out of the 7 trying to dispute the outcome of that particular process. And I've seen in some of the petitions, that is some of the issues that were listed. Again, the other thing that you have to look at is in some of the petitions, they even tried to talk about the Venezuelans who were arrested at the airport. Some also talked about the process of procurement. In other words, where we are finding ourselves is, have we complied with the place or the dictates of the Supreme Court in 2017, the 2017 presidential petition? In other words, are we still talking about the process being, I mean, the election being a process and not an event? In other words, we ask ourselves where we started from up to the end, how has the process been? But even as we look at the process, the big question is, has there been any issues within the process that substantially will affect the outcome of that particular election? In other words, even as we talk about the place of the 4 commissioners, are they trying to bring out big issues or serious issues that will undermine the outcome of the process? Even as 4 of the commissioners are talking about not having their place with respect to the tallying and verification of the results, are they bringing out any issues that will say we have not been given the opportunity, or we have not taken part in this process? Had we taken part in this process, the outcome would have been different. I think these are some of the serious questions that will need to be considered. But for me, the key issue that I look at out of all the petitions is the place of the 27 or so constituencies that have been listed under Raila Odinga petition, and that of the senator-elect for Busia, I think. These are some of the, yes, they were trying to question the place of the 27 constituencies, whether or not it will have had an impact on the final outcome. And I think that is why the big question is this: how, whatever allegations or whatever issues you're trying to bring up, will they be of such serious nature to affect the outcome? If you have issues, but they're not affecting seriously the outcome of the electoral process, I think it will be a bit different.
Okay, let me start back a little bit for the sake of Charles. Good morning. And morning. Thank you for joining us. Let me ask you, how enormous is it a task for the Supreme Court within 14 days to deal with 9 petitions, or 8 plus 1? I know you understand why I say that. At a time that you have so many respondents listed, if you had to look at the totality of all these cases, then you might end up with probably more than 10, more than 15 respondents in all this?
Yes. I think, Sam, the Supreme Court was prepared for this avalanche of petitions. There were amendments to the presidential election petition rules to create very tight timelines for exchange of documents between the petitioners and the respondents. There was compressed timelines to deal with what we call interlocutory applications. These are the applications that have to be heard before the main hearing. the Supreme Court decided already in advance that they'll not allow witnesses to testify on oath on the witness stand. This is what we call viva voce evidence, that instead they'll rely on affidavit evidence. They already decided they'll do the case management conference on the 8th day. That is basically next week on Monday. And after that, they will have a few days for a day-by-day hearing of the petition. So I think the Supreme Court is prepared. Even in the rules, they have indicated that they will give timelines for each of the parties, how much time they can submit, how many of the lawyers will be allowed to address the court. So this is a petition in which the paperwork, the documentation, the evidence in affidavits and the pleadings is going to have a lot of weight, because the parties will not have so much time to orally argue their cases. So I think the Supreme Court is prepared. They know they need probably 1 or 2 days to review the evidence after they have listened to the submissions of the parties and to give a verdict. They know that they cannot give a well-reasoned and full decision on the 14th day. They are likely going to do what previous Supreme Courts have done in the 3 presidential election petitions, where they give a summarized outcome, and then within a month or so, they give their detailed decision. So they are well placed to deal with the matter. And the fact that there are numerous parties is not so much a concern for the Supreme Court. Most of the respondents are the same. They are similar. So it's only the petitioners who are different. Okay. That would mean the petitioners will have to share the time that the court gives to the petitioners. What I would anticipate is the court might decide 1 full day. We give the petitioners, you distribute the time amongst yourself. 1 full day, we give the respondents, and then we retreat to write our, to review the evidence and to give a final verdict.
You said that the 8th day is Monday. When is the first day? Is it today or yesterday?
The first day was Monday, that is yesterday. So the 8th day can be treated as either Monday or Tuesday, depends on how you count. You could treat the 7th day as Monday and the 8th day as Tuesday next week, but it depends on how the Supreme Court does the counting.
Okay, all right. Of course, we are not in court, so we can't get into the nitty-gritties of it, but how important, because the basis appears to be very heavy on that Wafula Chebukati acted alone, that the 4 commissioners are not involved in the final processes. Also saying that the voter turnout was not clear. At some point had been declared to be over 65%. Eventually it was declared as 64.77%. Well, never mind, during that press conference, Wafula Chebukati was able to correct himself. But how important are those things going to be in determining this sort of petitions?
I think we have already discussed quite a bit as lawyers extensively the role of a few provisions of the Constitution, like Article 81 and 86 that establish the standard for free and fair elections, and then Article 88 and 138 that establish the role of the Commission, the IEBC, as well as the role of the chair of the Commission. We've also looked at the important statutes, most importantly the Elections Act, Section 83, which establishes the standard that the court uses when deciding whether to overturn a declared election result. I feel that the allegations about Chebukati acting alone, those are part of the context of determining whether there is credibility in the election outcome, whether the results actually were as generated at the polling stations and declared by the presiding officers in 46,000 polling stations and aggregated into 290 constituencies plus the diaspora vote, and whether what Chebukati did was a part of that process and system. So I think that is one of the issues that will be determined. I think the petition of Raila Odinga and Martha Karua has raised 2 other important issues that the court will have to deal with. And of course, we wait to hear the response of IEBC. One is captured in the affidavit of John Githongo, the former anti-corruption czar, who says that he received a whistleblower report that there had been manipulation of the Form 34As. And of course, we want to find out whether this was a genuine whistleblower or it was a hoax who gave the evidence to John Githongo. Of course, from a legal perspective, it could be argued that his affidavit constitutes hearsay. But Kenyans will want to know what is the response of IEBC to these allegations. And then you have the affidavit of Arnold Oginga, a lawyer, who says that there are numerous discrepancies in the voter turnout and in the totals for the various races. Again, we want to hear from IEBC team. Is it true that there are such discrepancies? If it's true, what is the explanation? If it's not true, what are the correct figures? So I think these are going to be like the core issues that the election petition will turn around.
Okay.
And let me just give a caution as I conclude that it is easy when you focus on the documentation of one side to be quickly persuaded by what they have alleged. But as a lawyer, you have to also listen to the other side. This is why we say audi alteram partem. It's Latin for hear or listen to the other part as well. So we have to very keenly wait to hear what IEBC and of course the respondents, including Kenya Kwanza, are going to say to these allegations.
Right.
And this is what the court will be doing. Then they'll be able to tell who's telling the truth and was this election free, fair, and credible.
Right. And Joe, what options does the court have? Because like what he says, that there's an allegation of manipulation of Forms 34A. There's also claim that there was a bit of a manipulation of the system so that you upload a form before it's presented, before the portal, there's a bit of switching a few things here and there. Yet at the verification exercise at the Bomas of Kenya, there was an opportunity for parties to verify with the original forms. So what options does the court have?
To answer your question directly is that the court is supposed to listen to both parties, and the Azimio side must substantiate the allegation, and the court must also listen from what IEBC and the Kenya Kwanza side are responding to those allegations. From there, they can determine if the election was held in accordance with the written laws of the land and in compliance with all the statutes that talks about the election. But going forward and give you a detailed issue about the turnout issue. There's in one petition, there's a petitioner who has raised the issue of the postponement of the elections for Mombasa and Kakamega affected the voter turnout, which eventually affected the presidential election. If you look at those areas, totally the whole country in other areas, there was low turnout, specifically like in Coast. If you look at Kilifi, Kilifi had the highest vote, low turnout at 16% compared to Mombasa, which had 15%. If you compare the results for 2017 and 2022. If you look at
Wait,
also...
what are you saying?
What I'm saying is this. In Mombasa specifically, the petitioner has raised the issue of not having the gubernatorial election leading to the low turnout, affecting the presidential election, and saying that Mombasa was a stronghold for Azimio.
The turnout in Mombasa was about 44%.
Was about 44%.
Right.
If you compare it with the 2017, which was around 56%.
59.
59. So that is around 15%.
Reduction of 15, yeah?
If you look at the Kilifi one now, Kilifi, you'll get the difference is around 16%. If you go to Tana River and if you go to Kwale and other regions within the coastal region, you'll find totally that region had low turnout. So some of these arguments, we can clearly start arguing and quashing them before even they are listened or they are substantiated in court at the Supreme Court. Okay,
all right, that's interesting. But Bashir, because what he's saying would appear hypothetical, even the claim by the petitioners would appear hypothetical that had you conducted the elections in Kakamega and Mombasa, then maybe the turnout would have been different and the outcome of the election would have been different. We may never know. how does the court balance those possibilities, the hypothesis presented before them, but also the allegation of political interference, especially within IBC? How does it balance or check against such while looking at the credibility of a process?
You see, Sam, when you look at how this particular, the kind of petition that we're anticipating and the determination as shall be rendered by the Supreme Court, it will be a shift from the past in the sense that at the moment we are staring at a court and at a time whereby the petitioners had an opportunity to even take photos of the forms at the polling stations. We had a certain channel through which the same was being processed. You see, when you look at that particular procedure, the way it has been undertaken this time around compared to previously when the data was in the hands of IEBC alone, I think things are a bit different at the moment. And that is, we are now at a time whereby even the petitioners should be having an opportunity to even present those particular forms at the polling station levels. And I think, Sam, you raised a critical question in the sense that you asked, what can the Supreme Court do at the moment? You know, when you look at Section 8 of the Elections Act, it can even undertake a recount before the court itself. There's a way it can order for a recount to see who has won in this particular election. But when you look, if we are to go that way...
for the 46,000 polling stations?
And I'm coming to that, Sam. If we are to go that way, in as much as the Elections Act provides or gives the court the powers to do so, that is not easy on the part of the Supreme Court, looking at the timelines. So I think, and that is what has happened, I think, in Kibwezi West. At the time, it realized that the petitioner had more votes than the respondent. We have a Supreme Court that only has 14 days to make a determination. What it can order for is to see the evidence that shall be shared with it by the various parties. It may even order for a scrutiny of those votes and sort of an audit of what has happened. You know, if we need to see what has happened, if at all the interest or the rights of the petitioner has been prejudiced, the Supreme Court shall go for it. Look, while still being considerate of the 14 days that we have in as a country. But all the same, we are staring at two things generally: either an annulment of that particular presidential election or an upholding of the results of the outcome of that particular election. These are the two scenarios that we are staring at. Even as we stare at that, what are some of the things that we are looking at? What we are looking at is questions that affect the outcome of that particular exercise. The final numbers that we're having, the aspect of telling us if you're having questions on the 65.4% voter turn-up, if you want to question vis-a-vis what the total number of votes that were given to the four contenders, it's a question of maths. You can share with the Supreme Court you're part of the story and how it affects the aspect of the 50% plus one. I think these are now some of the crucial issues that we can talk about. If the other serious issues that the Supreme Court will consider is the aspect of the 27 constituencies that were left out. Will they be having a final bearing on the outcome of the presidential vote? That is another thing. What we also need not to forget is the integrity of the entire process. Has the process been neat? You know, the neatness of the process is equally important, because looking at the outcome of the 2017 presidential petition, what the court questioned was the aspect of the transmission of results. It ended up questioning the integrity of that particular electoral process. And I think even right now we are staring at two things: the neatness of the process, the integrity of the entire process, vis-a-vis the outcome of that particular exercise. The question of numbers, and when you look at the petitions, all the petitions seem to be raising the similar issues. I think the question of quorum, the question of the 65.4% vis-a-vis the total number of votes that were garnered by all the four contenders, these are issues that are cutting across in all the petitions. And I think that's why we are talking about the Supreme Court staring at more than 10 crucial issues that it shall have to make a determination of. But the final outcome shall be either over two, either an annulment or an upholding of the outcome of the exercise.
Very interesting. And if my memory serves me right, in 2017, the court didn't exactly go to the numbers. They stuck to the process. I want us to take a look at some of the feedback that has been coming to us on the show before we can continue. This is Engineer Lazaro. Let's applaud Raila for choosing judicial processes and calming down his supporters from bitter demonstrations. It's now time for judges to restore dignity of the nation, which has been adulterated by reckless impunity of an individual. I don't know what you mean with that. Bobo Tieno, it will be hard for the Supreme Court to nullify President-elect William Ruto's win. I think we had read this. The people's will and choice. Moso IBC conducted elections transparently like no other. Kinyo Mushoki, the petitions filed yesterday are a huge step to test the tenets of our democracy. Naftali Akao, BBI was nullified because of lack of IBC full quorum is one of the reasons for failure. Presidential results announced by 3 commissioners. The Supreme Court, the ball... Wow, okay.
In your court.
I bet that's what they meant. Now, so there has been requests that there be conducted a Kim's Kit audit, an audit of the election technology. The Khalifa is it? Petition raises questions about the KPMG report that it was never implemented, it was never made public, and especially in the processing of the voters register. Yet, very few days, how can the Supreme Court move ahead to grant some of these requests or applications?
So Sam, the first 4 days, actually the first 5 days of the 14-day window is for the respondents to prepare their responses. They have 4 days, and then the petitioners to do a rejoinder, and that will happen on the 5th day. That is when the pleadings close. So then you have this period between day number 5 or day number 6 until probably day number 11 or 12, when the Supreme Court will deal with the interlocutory applications and give directions.
Right.
And most likely they'll not even allow parties to submit before them. They will just look at the papers that have been presented. They will expect the respondents to reply to the applications, probably by day 6 or day 7, and they'll give directions. We saw in 2017, in the first petition of Raila Odinga of 2017, that there were also requests for scrutiny. They requested for the servers of IBC to be opened, and the Supreme Court actually gave certain directions. IBC found it quite difficult to comply because they were given a very short time period of 24 hours to comply. We also know that the Supreme Court gave directions for retallying of the Form 34Bs, and there was an exercise that involved the registrar and review of the forms. So the Supreme Court is able to give some prayers to facilitate the disclosure of important evidence. Right. At the same time, the Supreme Court is aware that the timelines are very limited and the amount of work that can be done is not so much. So what has happened is that the petition of Khalifa, even the one of Raila Odinga, have requested that within 48 hours after the filing of the petition, that IBC discloses a lot of data from their Kim's Kit, from their server logs of who has attempted to gain access and so on. However, under the rules that have been prepared by the Supreme Court, there is only one set of documents that IBC is required to provide within 48 hours of the filing of the petition. And that is a complete set of the certified copies of the result declaration forms. They have to provide all the 46,000 Form 34As, the 291 Form 34Bs, and the 3 copies of the Form 34C that they have prepared. For all the other material that is requested, it will depend on whether IBC chooses to supply it while doing its response on day 4, or if the court gives further guidance, probably on day 5 or day 6, for IBC to supply that information. So you will need to have technical experts on both sides ready to comply with the orders of the court, and if the court makes orders, to review the data that is likely to be provided. And the data is likely to be quite voluminous. And so the ability to do a deep dive of the data, even if it was to be provided, would be somewhat limited. Only some measure of sampling is possible. Right. In regard to the issues about the KPMG report, the same considerations apply. The KPMG audit report probably includes, apart from the cover report, a lot of supporting data and documentation. And the question of whether that will be provided, of what amount of use it will have, considering the limited time, those are issues that the Supreme Court judges will grapple with, as well as the parties who will be appearing before the court.
But what would be your take? Because, and sorry to get you through this, because around that time, I think it was June 20th, the IEBC team of commissioners spoke to the media and said that, yes, there was a KPMG report. We have acted on some of those issues, and this is the report. This is an account of what we've done. Then Khalif Khalifa is raising some more questions that based on, it appears they have accessed the report, that there are people who are in the register that shouldn't. Yet IBC said for those that resolved issues, we'll ensure that people identified biometrically so that they're able to confirm that it is indeed you. Does that mitigate the impact of what Khalif Khalifa may want to prove to the court?
Let me say this. There is no single voters register anywhere in the world that has 100% integrity. And for various reasons, people die, people move from one place to the other. Sometimes you have multiple registration, and those things have to be cleaned up. And that is one of the reasons why KPMG was involved in the process of trying to clean up the register. But there's no register that is 100% perfect. Mm-hmm. In fact, the court itself has stated on several occasions, and this is the kind of like anchor of Section 83 of the Elections Act, that there's no election that is perfect, that doesn't have discrepancies. The question is always, were the discrepancies so substantial, were they so grave as to affect the credibility and the validity of the election result? So what I would anticipate is that IBC would be arguing that, yes, there may have been some challenges in the voters register, but the system put in place for identifying voters that included the KIMS kit, biometric identification, that included the presence of agents and observers at the polling station, may have mitigated against some of those challenges with the register. And really it will be for the court to weigh the arguments of both sides and see, are we persuaded by what Chebukati or IBC is telling us, or do we feel that those claims that were made or findings that were made in the KPMG report were not sufficiently addressed, and therefore they have affected the credibility or verifiability of this electoral process? And that's why we have the Supreme Court, because each side will have their set of arguments. And ultimately the court will have to decide. There are 7 wise men and women who will look at the evidence, look at the law, and decide the outcome for us all.
And I normally feel that the 14-day period is normally a serious problem on the part of the judges, especially with respect to the kind of forms that they're supposed to go through, the kind of workload, the kind of evidentiary materials that is shared with them. It's normally a very constrained timeline, especially looking at all the players in this particular case. But ultimately, I think it's a game of both the process and the data, and to see how much it has substantially affected the outcome of the process, whether or not it has really interfered with the integrity of the electoral exercise. You know, one of the claims that I have seen being the aspect of turn up. You know, there are things that you can have a look at and deal with them there and then, especially with questions of data, the questions of calculation. There are things that can be done. But when you talk about manipulation of forms, you know, it takes a toll effect on someone to now see how that particular manipulation has taken place, whether or not hacking has been undertaken. The number of times a certain system has been hacked, maybe with a view to maybe substituting a certain form 34A with another form. I think these are now the serious issues that may end up calling for some sort of expertise, assistance to see technologically how that may have happened and whether it has really happened. And I think that is what may have some tall order on the part of the judges. Okay,
and I'm looking at an update from the Judiciary, Charles, and they're saying that pre-trial conference, or the case management conference, will be on Tuesday, 30th of August. So that appears to be the 8th day. But Joe, looking at some of the issues raised by the petitioners are that some 27 constituencies, I thought there were 31.
27.
Plus 1.
They have raised 27.
Yes, that they were never announced at the National Tallying Center. How important is this at a time that during the day of the declaration, we would see the agents of the presidential candidates being called to a meeting? Of course, it was not in public, so we don't know the content of those meetings. Eventually, we saw some chaos. How can IEBC explain this?
It's not specifically on IEBC to explain, but it's how the petitioners are going to raise the question, how they are going to raise the issue. Because from my understanding, the presidential elections are announced at the polling station, which results to Form 34A, which are then transmitted to the tallying center. At the tallying center, at the Bomas, is where the tallying and the counting happen, so that it can help the national returning officer to declare the presidential winner. So it's how they will raise the issue. And if you look at the way they are bringing out the issue, they are bringing in the issue of the hacking and replacement of Form 34As. But for those who are keen at the process that was ongoing at Bomas of Kenya, there is no single day that the petitioner, specifically the team from Azimio, provided a specific Form 34A of a particular polling station that differed with that one that was downloaded from the IBC portal and that one that was issued or was announced at the polling station. So it's how they have raised the issue, cumulating to 27 constituency, and how IBC is going to respond. Because on the night before the following day that the results were declared, there were some issues pertaining, and even not even on the night before, the whole process, there were some issues where you could find commotion within the flow of where the tallying was happening and the verification. Clearly, there were some efforts to try and undermine IBC not to declare those results or announce those results.
So what is the place of those things you're saying before court?
So it's about how the petitioners have raised it and how IBC is going to respond to those issues, on how it ended up not being able to announce the 27 constituencies.
Sam, if I can add,
yes,
I think there is no question that the IBC commissioners did not publicly announce results of about 27 or 28 constituencies at Bomas.
Right.
There's no question. But then let's remember that those results are meant to be first announced at the constituency tallying centers by the CROs, the constituency returning officers. Let's also remember that when they went to Bomas, IBC had a mechanism for uploading the Form 34Bs. And their argument will be that we may have failed to announce them publicly, but we uploaded the forms on the portal and the data was transferred to the 34C. So what is being stated by the petitioners is correct. We all witnessed last week on Monday, we were waiting for the announcement of those 27 forms, and the country was gripped. We were on tenterhooks. We didn't know how the tally was going to go until the final result was announced. So there seems to have been a failure or an omission by IBC. IBC could argue that there were various reasons of security and otherwise that made it impractical for them to declare those 27 results publicly, but that notwithstanding that failure, those results were shared publicly and they did not change from what was announced in the constituency tallying centers. That is a legal argument. That is for the court to decide. Do we agree with IBC's explanation, or do we think that this was such a fundamental failure that it went to damage the credibility and verifiability of the tallying process? That really is what the court will decide on that issue.
And Bashir, from what I've read, it appears the issue is them not being announced. I'm not sure I've seen an issue of whether the results from those constituencies are verified.
You see, Sam, what they are alluding to is that if this result, in as much as they were not announced, if the petitioners are to prove that these results were not announced, but something has happened that amounts to an electoral offense, issues to do with how any manipulations might have undertaken.
Right.
I think that is what they're trying to allude to, that these results were never announced. Maybe something has happened underhand. But you see, Sam, one of the things that I keep saying is, for me, I voted in Wajir County. And in one of the constituencies, the entire election had been postponed, being a last constituency. Yes. And the results, especially with respect to the declaration of the member of parliament for Wajir North, for example, and Eldas, was announced, I think, hours to the declaration of the president-elect. So I think they are trying to show that in as much as you did not announce this result as required, maybe if there are any manipulations that might have been done on these particular forms, we be having some issues with that. But I'm asking myself, even practically, if you could not announce the result for Eldas constituency, the member of parliament, if those results ended up being counted as part and parcel of the results for the woman rep for Wajir County and the governor-elect for Wajir County, those results ended up coming out towards the declaration, I think the final days of the announcement of the presidential results that we have had. So the big question is, actually, the member of parliament-elect, for example, for Wajir North, was given his certificate 48 hours ago.
Yes.
So you see, these are now some of the issues that they are trying to show. They're actually saying that we are questioning the integrity of the process. You know, it is trying to show that the neatness of the process was not so good. So I think this is now part of the arguments that the petitioners are now trying to use. They're trying to bring forward the aspect of saying, look, this process has not been clean. And I think some of the examples that they might also be trying to show is that lateness, that delay. What has it been occasioned? Is it a reasonable delay? If it is not reasonable, what is it that has actuated that particular delay? If there is more than meets the eye, we expect on the part of the petitioners, as they have alleged, it's on the part of the respondents to show that in as much as we did not declare, we did have this particular delay, it is reasons A, B, C, which are reasonable, that have actually caused that delay. But I'm telling you for a fact, some of those things that we have witnessed in parts of the country is what is actually making the petitioners question the integrity of the process. There is one more thing, one of the more things that I've actually observed is that we need to ask ourselves, of these constituencies that are being questioned, will they be having any impact on the outcome? Look at the numbers.
Yes, they will. They will have an impact. I think the issue that Sam was raising is those 27 or 28 constituencies, were the Form 34Bs verified? Were they even signed by party agents? Because if there was a verification process, if they were signed either at the constituency tallying center or even at Bomas after verification, then IBC would be saying, we did the verification. These are the figures. Do you have alternative figures? So IBC will have their argument, and the question will then arise, is this announcement, this oral announcement of the result, is it very material? Is it very important? And do you announce the results both at Bomas and at the constituency tallying center? Because in the case of IBC versus Minor Care in the Court of Appeal, the court said that the Constitution says that the election for president will happen in the 290 constituencies. So that it is actually 290 elections that are aggregated, the results are aggregated at Bomas. So IBC will be arguing that that election in those 28 constituencies took place, and the results were aggregated in the constituencies. They were declared in the constituencies in the presence of your agents. And when they came to Bomas, even though we didn't announce, we just verified and we uploaded them on the portal. Right. So you see, these are actually legal arguments that are founded on a factual underpinning that the court could decide either way. But clearly, both sides have a legitimate argument to present to the court.
Would re-verification be one of those routes to follow for the court, for those specific 27 constituencies?
Indeed, whenever there is a question regarding a process, the court is meant to ask itself, was this so material that it could have impacted on the result? And this is what Section 83 of the Elections Act presents as a test for any election court. And when an election court is doubting whether there could have been an effect on the outcome, one of the natural recourse that the court has is to order either recount or retallying in this case. And it could be a general retallying for those 28 constituencies, or a sampled retelling where they pick a few constituencies that have been highlighted in the petitioner's arguments by Raila Odinga and by Helef Khalifa, and say, let's retally this constituency and this other one and see what are the discrepancies. And what my colleague has said is also true, that the court will also want to know, do you have alternative figures? Do you have your own set of Form 34 A's or B's? If you don't have different set of figures, then we are left with that situation of we'll only have to use the 34 A's that have been certified and presented by IEBC to the court.
Right. I want us to take a short break because you're getting, not a break, but a look at the feedback because you're getting to the tail end of the show. This is Karanja saying that the first two petitions explicitly dealt with systemic issues, including the process and infrastructure. Notably, a system is as good as the people working in that ecosystem. This petition should focus on recommendations on the conduct of those who interact with that system. Engineer Lazaro again, Chebukati acting alone during the deafening moment already infringes the electoral laws, lack of quorum, heated IBC during the final tallying. I'm not sure I understand there. Someone else is saying, this is John, you're saying that can the Supreme Court declare the chairperson unfit to hold public office, considering Article 251 sub-Article 2 provides alternative mechanism of seeking removal from office of a member of an independent commission, that is through the National Assembly. And I think, Joe, we can respond to that because there has been some of the prayers there is to find that the commission as presently constituted cannot conduct a credible election. Is that something that the Supreme Court would want to get into? I know in 2017, they refused to go that direction in expressing themselves in as far as the conduct of specific officers of the IBC. Would they this time?
Specifically, the matter before the Supreme Court is an election petition, and the court will try to, in fact, to answer the question is just that if the Chebukati is to be declared unfit, it needs to be a different case from this one, and to raise the issues or to raise the finding from the Supreme Court and other relevant agency to raise a different case so that you can declare Chebukati unfit and follow the due process that is needed to remove the commissioner. But also, there is also a clear indication from the petitioner where they are saying that if the Supreme Court finds Chebukati to have caused the illegalities and the irregularities that has affected the outcome, then they should, if they declare a rerun, Chebukati should not be the one to conduct the election. Looking at the timelines, looking at everything involved, if we go that route, then our hands are tied. It will be another crisis that need to be sorted out, because after the declaration, there is a specific timeline to hold a rerun of an election. Within that specific timeline, can we be able to have other commissioners on board so that they can do the election, which is practically it's impossible.
Charles, what's your response to that?
I think one of the biggest challenges for the petition by Raila Odinga and Martha Karua is a non-legal and non-factual issue or reality. It is an issue that will not be presented to court most likely, but will be in the backs of the minds of the judges. And that is arising from a certain attitude that courts have, that courts will not act in vain. And so they will be asking themselves, the judges will be asking themselves, if we grant these orders, how will they be implemented? And I think what my colleague is saying is that in 2017, the Supreme Court decided to nullify the result. They did not make any follow-up orders. Thereafter, the NASA team made a demand for IBC to be reconstituted and said they will not participate in fresh elections. This time, the Azimio team has decided to foresee the consequence of a nullification. And they have said they want Chebukati to be declared to have engaged in electoral malpractice and also for IBC to be reconstituted. So what this would mean is that the judges would have to ask themselves, if we give this decision, how will the repeat election be carried out? What are the practicalities? The repeat election is meant to take place within 60 days after the court declaration based on the Constitution. Those timelines cannot be changed. There is already a High Court decision by Justice Mrima saying that the amendment to the IBC Act that introduced a new mechanism for selecting IBC commissioners was unconstitutional, and that even the 4 commissioners who came in through an unconstitutional process, even though they would be allowed to continue serving.
I think it's one of them. Irene Masit.
No, all 4. There are 2 decisions of Justice Mrima. One touched on Masit and one touched on all 4 commissioners. And it said that the amendment to the IBC Act was unconstitutional because it gave too much power to the Parliamentary Service Commission to select 4 out of 7 slots. So to reconstitute the commission, you need to amend the IBC Act through Parliament. You need to go through a new selection process. And then after that, it will still go to Parliament. The new commissioners would have to be approved by Parliament, appointed by the President, who happens to be the chair of Azimio Council, get into office, understand what is going on, and carry out the election. So it is a very complicated issue. On the other hand, they could remove Chebukati and leave these 4 rebel commissioners. Then you find the Kenya Kwanza side saying, we have no confidence in these 4 commissioners. So it is a major saga of how will IBC be able to carry out a repeat election. And this is an issue which, even though it is not a legal or factual issue in terms of credibility of the election, it is going to be at the back of the minds of the judges of, if we choose to order a repeat election, how will this take place practically? And I would recommend to both parties, Kenya Kwanza and Azimio, to reflect on this, because as they present their submissions to court, they'll need to be able to explain to the court, if you give such and such orders, how do we propose that those orders are carried out in the next 60 days?
At a time, Article 134, Sub-Article 2, specific to B, the President, during the temporary incumbency, cannot nominate or appoint any other public officer whom this constitution or legislation requires the President to appoint. So really, I'm not sure he would be in a position to appoint a new commission.
Exactly. That adds to the further complication. But there's something we call the doctrine of necessity that sometimes can kick in such situations.
Okay. Bashir, we have to end. But for you, what would be the maker or breaker of any of these petitions in the next 14 days, or 13 now?
For me, Sam, the core petition, these are 7 petitions, but as I've said, most likely these will be consolidated as one, with the Raila Odinga petition being the major petition, sort of. But weighing into that particular discussion on the place of the chairperson, we see that part of the serious grounds that were leveled against the commission largely center around the chairperson as the returning officer of the presidential election. Meaning, in the event of an annulment, you ask yourself again, you are sending us back to the same chairperson who has presided over that particular election event, the presidential election. Meaning, how are we going to submit ourselves to somebody who was responsible of bungling an election? In as much as we are looking at the timelines and the possible ways of maybe replacing or reconstituting a commission, here on the other part, you are looking at someone who holds a public office, who you leveled allegations of bungling an election, who may be, in the event of an annulment, even in as much as the Supreme Court may not grant such an order, you are again going to submit yourself to the same commission, chaired by the same chairperson, and who is supposed to again be the returning officer of that particular election. And I think it's again, it will put us in the same scenario we have seen placed in the 2017. You know, in 2017, I saw the NASA leader at the time protesting the constitution of that particular commission, saying that he will not be comfortable to submit himself before that particular commission in a repeat poll. And I assure you, Sam, just like Senior Counsel Kanjama has put it, this time around, the petitioners are a bit sensible in putting that particular prayer inside there. They are trying to imagine, in the event of an annulment, they want the Supreme Court judges to reflect on that particular instance, that in the event of an annulment, you would want us to undertake a repeat poll, but again, we shall be presided over by the same commission chaired by the same chairperson. It's at the end of the day, we hope ordinarily the courts of law make reasonable decisions. Courts do not make decisions that end up putting the country in anarchy. Courts are quite sensible and are practical. I do not expect the courts to make a decision that will end up putting us in jeopardy, looking at the 60-day period within which we are supposed to have the repeat poll. But we should not forget that the office of the chairperson of the Electoral Commission is a public office, and he has a mandate as a public officer. He has a constitution to be bound by. He has the principles, and he has those values and principles of the constitution that he must abide by. Meaning, in the event he is found to have centered around a bungled election, he will equally have a blame to carry on his back, in as much as he is presiding over an independent commission, meaning we are looking at the same players, submitting before a poll to be presided over by him again, in as much as we are looking at the risk and the timelines of 60 days of having a repeat poll, the complexities of replacing these commissioners, but we should not forget the fact that these petitioners have a right, and their rights equally are so crucial to the courts of law. So I hope the courts shall be in a position to guide us as a country and see to it that even as they look at the various prayers put forth by the petitioners, the best possible scenario that shall not put our country back.
Okay, all right. And I want to thank you all for making time for us this morning. Suleiman Bashir, Joe Halende, and Charles Kanjama. Asanteni sana for having this conversation. We hope to do more to bring you the latest in as far as this process is concerned, even as we try to bring out what the petitions contain. Of course, the timelines are already clear, including the situation that by yesterday, of course, you saw the filing. The respondents are supposed to be served by today, and they are supposed to file their responses by 27th of August, which is this Saturday. The rejoinders should be coming, that is from the petitioners, should be coming on Sunday, the 28th. Interlocutory applications should be filed and served by Monday, the 29th of August. And then the responses to the interlocutory applications should be coming the following day, which is on Tuesday, the 30th of August. And that should also be the first day or the day for case management conference. Then third party, that is friends of the court, application should be coming on the 31st of August. Charles, you were not lucky last time.
Yes, indeed.
Are you hoping to make an application this time?
Once bitten, twice shy. I think the court is grappling with so many parties that they are likely going to limit the number of friends of the court or amicus curiae that they will admit. And they have very clear guidelines on who can be amicus.
Okay.
Most likely it will be institutional players who they may admit, like the Law Society of Kenya, maybe a constitutional commission, maybe observers. So we let those who feel that they are experts and they are non-partisan make the applications to the court. Okay, all right.
But Charles is also an expert on election.
On 5th of September, we will know the outcome of this entire process. My name is Sam Kituku. See you some other time. Bye for now.